Okay, in this video, because it's been a while since I did Lori, and I love doing Lori. She's so simple. Now, Bullhorn, she's really hard to do. Okay, now, she's talking about Lori Hellis, just a tiny bit from her last hearing. Oh, let's see what else. Oh, she's dancing in her cell. And before you get to that part, when I'm having the interview with Nate, turn down your volume because the ending will be loud. Enjoy.
Did you guys miss me? Yeah. I missed you. Dad. Hi, Dad. Hi. I miss you. I miss you so much. Yeah. Okay. Yeah. Okay. I know, right? Shame. Okay. Sit down. Okay, I'm sitting down. Okay, here we go. Yeah. It's been a while.
And it blows my mind that after 2 years, I can't get the simplest items of discovery in a case. And I would think this would be a priority to the state. And yet they're not providing me this information. And I want this information. In addition, at the last hearing, I believe last month, I sought a transcript of a grand jury proceeding. And there was opposition by the state to have them provide that to me initially. They initially then conceded that, oh yes, I do get it. But to date, I don't have that grand jury transcript, and I have no idea when I'm going to get it. And just because it's handed to me doesn't mean I have time that day to go over the transcript and evaluate it. Because once I get the transcript, I'm going to have to evaluate what witnesses I need to talk to, what information I need to convey, and then I'm going to need to sit down with Mr. Daybell and go over that transcript and discuss, how that affects this case. So it isn't as simple as them dropping something off to me and saying, here you go, you've got it, let's roll. It doesn't work that way, and they don't get to do that. They need to afford me adequate time to prepare. And it's not my fault, regardless, it's not my fault that I don't have all the information. And I'm not putting specific blame on this prosecutor's office.
Oh, yes,
I don't know what law enforcement is doing and how, what their procedure is to get this information to them. But at this point, I don't have it. So my position is simply this: at the early
anything past February 1st, 2023, and here's how we get there. She, when the grand jury indictment initially came out, she was hospitalized and returned from her commitment in April 2022. So her right to a speedy trial started in April of 2022. So 6 months by statute, by court rule, and by our Constitution of the United States and the Constitution of the State of Idaho, have been interpreted that a speedy trial means 6 months from arraignment. So for the 6 months from arraignment would put us at October of 2022. The court initially gave her a trial setting, was respectful of my client's rights to a speedy trial. So the court set it for October of 2022, and we appreciated that. A motion to continue was then filed by the state, asking for additional time. And the court found good cause to postpone the October 22 court date and moved it to January of 23. In the interim, our case was stayed or told for approximately 6 weeks. So when a case is stayed or told, that adds to the speedy trial time under our case law. So that's where we get to the date of
motions hearings in anticipation of pretrial motions that will be filed, and that's the date we will start the trial at this point. So, in lieu of asking if there's any questions on that, I think that's just a pretty clear answer for everyone. That's when trial is going to begin in the case and will be scheduled. I've considered all those concerns, so we'll submit a scheduling order in the case.
There is no
It
case.
will provide other deadlines and times when things need to be filed pre-trial. We'll also set forth some scheduling in terms of pre-trial motions. So that's the ruling on the scheduling conference for today. All right, at this point then, we do have additional motion hearings, and those are only in the 1624 case with Mrs. Vallow Daybell. So at this point, we are going to have Mr. Daybell excused from the courtroom by the marshals. If the public would please remain seated while security takes care of that issue. We'll then move on in a moment to our next motion. You may be, Mr. Pryor. Thank you.
A little bit rich when they haven't even complied with the rules either, or haven't complied with the rule.
Would somebody shut that guy up?
I think there's some very false assertions made in their motion to compel.
You lied.
Positions taken by the state we've never taken.
Holding secrets.
We address that in our response, so I won't go into that here. But again, we have complied with the rule.
Shut him up.
We will continue to comply with the rule. I think their request goes well beyond what Rule 16 requires.
All right, thank you, Mr. Wood.
Your Honor, may I
Rebuttal, Mr. Thomas.
ring any bells with you?
One or two.
Okay. So let's talk about Melanie Pulaski. You specifically met with her in the last several weeks, is that right?
Yes, he did.
And why is it that you met with her?
I was assisting our mitigation expert
They're assisting me.
with a multitude of interviews.
The queen.
You met with her for a specific reason. We had you meet with her for a specific reason, is that correct?
It is.
And what was that reason?
It had to do with her having an interview or being called by the state.
Ruling. Any question on that ruling, Mr. Wood?
No, Your Honor, thank you.
All right. That'll conclude the motion to compel then. The next matter we have scheduled is a motion entitled Motion to Declare the Death Penalty Unconstitutional and to preclude its application in this case because empirical research has established that modern death penalty is as unguided, arbitrary, and capricious as the system of capital punishment struck down by Furman v. Georgia. Counsel, there was some discussion in chambers before this that Mr. Pryor indicated he would be filing a similar motion and that perhaps the parties could hear that in a joint hearing. At this time, let me ask from the
Hi, Nate. How are you? I bet you guys thought I wasn't gonna be around. Oh, what happened in court? What happened? I showed this to the prophet, the only real true prophet. Yes. Yep. Hold on a minute. Okay, I'll be good. I promise. Hi. Hi, everybody. I didn't forget about you guys. No. So, Nate, let me ask you. Did you get your book yet? The Gathering. The Gathering. We're still gathering. think this is gonna stop us? No, because we're strong. We're a strong cult. Also, here it is. I told you. The prophet wrote a book about him. A prophet. Chad, don't lie. Never. Chad, don't lie. No. Get your book. Don't forget. So, anyways, my face ain't orange. It is? My face is orange? Oh. Well, in Canteen, all I can get is Wet and Wild. Yeah, Wet and Wild. That's it. Don't look orange to me. Does my face look orange, guys? So anyways, yes, a lot's happened. They think they're gonna do the death penalty on me. No, they're not. Nobody can kill me, because I'm the queen of the 104.44, yeah. So now, there's this Lori Hellis going around. Yeah, I'm getting a little excited here. She calls herself attorney. She failed in court. She's only there for herself. She ain't there for the public to be, everything to be transparent. Because everything's out there. Everything. Everything that needs to be out there is out there. Okay? I know what you're doing, lady. Trying to get a fast buck off my name. I got you. Chad's got you. So, she's fake. Don't buy her book. Yeah, buy Chad's. Not hers. So what else has been going on? Well, I found out I wasn't cuckoo no more. Couldn't play it off no more. Hey, I can say it now, I don't care. Because you know what? No one gets to see me in the courtroom right now. That's why I'm dressed in this shirt. But I got to pick my shoes out. Sure did. I miss Chad. Yeah. I hadn't seen him forever. And then I get kicked out. I showed you why. Yeah. Let's do a part 2 because I'm really tired from court, okay? Okay, Nate? Alright. Love you guys. Bye.